So as you've already heard, this is an interactive exercise, and I'm going to take on multiple different personalities. And I'm going to have you take on multiple different personalities. And I don't know about you, but it helps me sometimes when I want to do that to get some medicinal assistance. So I brought a little, I have to be careful because this is going to be on television and I don't want to be arrested later. But I've got something here that I'm going to take that's going to help me take on multiple personalities. But even more than that, it's going to give me the power to cast a spell on you so that you can take on multiple personalities, okay? So I just thought it might be fun for you to guess what it is I have here in my fist. I'll give you a hint and see if you can figure it out. I have a friend who practices law in London, and she represents J.K. Rowling, who wrote the Harry Potter series. And this comes from J.K. Rowling, what I have, and it will help us all take on different personas. What have I got here? Do you know? Yeah? It's polyjuice. In fact, it's super polyjuice. It's super polyjuice black label, all right? So let me just take a little. Transformicus supreme corticus. There is a vacancy, multiple vacancies, to be justices of the United States Supreme Court. I am now playing the role of the President of the United States. I nominate all of you to be Supreme Court justices. By the way, what now happens before you become a Supreme Court justice? Yeah? You have to be confirmed by the Senate. You also get a background check. The FBI looks into all of your backgrounds. I hope you have nothing to be ashamed of, nothing to hide that would be embarrassing. Well, good. You apparently don't. You've all passed the background check. Now I'll play all 100 U.S. senators. I'm all the Republicans. I'm all the Democrats. I am the entire U.S. Senate. And because of your extraordinary education at Lebanon High School and then later college and law school, this never happens anymore. You are unanimously confirmed to be Supreme Court justices. All right, so there's one more step. The last step is I'll be the Chief Justice, and I need to swear you in. So assuming you're capable, would you please stand and raise your right hands? And please repeat after me. I do solemnly swear or affirm.
I do solemnly swear or affirm.
That I will faithfully execute.
That I will faithfully execute.
The position of Justice of the United States Supreme Court.
The position of Justice of the United States Supreme Court.
I will do equal justice to the rich and the poor.
I will do equal justice to the rich and the poor.
And will to the best of my abilities.
And will to the best of my abilities.
Preserve, protect, and defend the Constitution of the United States.
Preserve, protect, and defend the Constitution of the United States.
For roughly the next 45 minutes.
For roughly the next 45 minutes.
Congratulations, Your Honors. Congratulations. Your Honors, as you know, one of the perks, not only do you get free parking under the Supreme Court building, but you have a law clerk. I will now serve as your law clerk. I know this is your first case. You've read the briefs. But since it's your first case, you should know that by tradition on the court, when an advocate comes before the court, they are given anywhere from 10 or 15 seconds to 2 minutes before the justices begin to interrupt. And before COVID, the justices just in a free-for-all would interrupt. When I argued a case in the Supreme Court for 30 minutes before I became your clerk, when I was a lawyer, I actually argued a famous case in the U.S. Supreme Court. And I was asked 70 questions in 30 minutes. So a question about every 30 seconds. So you should feel no inhibition, even as a first-day justice, in putting your questions before the advocates. You don't have to raise your hand. You can just say counselor or Mr. Smolla. That's the name of the first advocate you'll be hearing. And just pop your question, and the advocate will do the best he or she can to answer the question. So I'll now be the marshal of the Supreme Court of the United States. Oh yay, oh yay, oh yay. The Chief Justice, the Associate Justice of the Supreme Court of the United States. All persons having business before this court are admonished to draw nigh and lend their attention, for the court is now sitting. God save the United States and this honorable court. Mr. Smolla, you may proceed. Thank you, Chief Justice. Chief Justice, may it please the court, I'm Rodney Allen Smolla, and I represent the petitioner, Tina Bay. Your Honors, there is no doubt that my client could have recorded this video, a song that she wrote, and played it for the world to listen to. And there is not a thing any governmental entity or any private person in this country could possibly have done about it. That is to say, it would be unthinkable that the police could come and arrest my client, a high school student, because she wrote a song on YouTube, criticizing a decision of this court, criticizing people at her school, even though laced with vulgarity. We don't send people to jail for things like that. She's committed no crime. The First Amendment would plainly protect her. Nor could anybody sue her. None of you justices could have sued her for anything because she was critical of some of you for your decision in the football coach case. None of the other students could have sued her. What would they sue her for? People in this country have a right to write songs. People in this country have a right to write critical songs. They have a right to use the F word in their songs. And there is nothing the government can do about it under our modern First Amendment.
What was the song about?
Your Honor, she is conscientiously opposed to religious rituals on high school property.
What rituals?
Your Honor, the head football coach at her high school, after football games, would go to the 50-yard line and say prayers and ask others that wish to join the coach in the prayers to join him.
Counselor, were these optional?
The prayers were optional, and the issue of whether the coach is right or wrong isn't before the court. You ruled in an almost identical case for the coach. My client thinks you were wrong, and my client has a right to say you're wrong. You were wrong to overrule Roe v. Wade. You were wrong to rule in favor of President Trump. Nobody has to agree with the decisions of this court, and anybody that wants to write about it. If Jimmy Kimmel wants to go on television and say the Supreme Court just decided this and it's wrong, you can do that in this country. So she didn't like your decision. She didn't like what the football coach was doing. She didn't like the students that were joining in it. She didn't like the teachers that were joining in it. She didn't like the principal. That's breaking news. High school student doesn't like the principal. She didn't like any of that. She wrote a song about it. And because some people didn't like the song, by the way, a lot of people don't like songs. They don't like songs critical of something. You know, hip-hop artists war against each other. Kendrick Lamar wars with Drake over songs. It happens. You have a right to do that.
Counselor, did this song have any threatening words or language towards any other students in the school?
Absolutely not. The school board took the view, the district court took the view, the Court of Appeals took the view that the refrain, I know who you are, I know where you are, I know who you are, I know where you are, is a threat. It's our position, Your Honor. Get serious. If it was a threat, a prosecutor could put her in jail for that. That's not a threat. Does it refer to guns? Does it refer to violence? This is a high school teenage girl. She was threatening you Supreme Court justices? That's crazy. She was threatening the football players, the football coach? That's crazy. I know who you are is not threatening. The only thing they're hanging themselves on is I know where you are. I know where you are is not a threat.
Counselor, would you define a threat as something that only refers to guns or violence or weapons of some sort?
This court gave us the definition of threat in 2 cases, at least 2, maybe more. In the Watts case, here's what the court said was not a threat. I'd like to take the President of the United States, I'd like to take LBJ in my sights and shoot him. And you said that's not a threat. That's anger, that's frustration, that's hyperbole. It's not a serious claim that you're going to shoot the President of the United States. In Virginia versus Black, you said just because the Ku Klux Klan engages in the racist ritual of cross burning, that doesn't in itself constitute a threat. That's the Klan's ritual. It's hateful, it's evil, but it's protected under the First Amendment. And then most recently, in the Counterman versus Colorado case, in which someone was stalking and scaring a singer-songwriter in Denver, you said for it to be a threat, there has to be a conscious risk that you are engaging in speech that would be understood as placing people in threat of bodily harm. That's the official test you gave. And it's our submission you can't possibly squeeze out of these song lyrics a threat.
Counselor, where was this video taken and posted?
It was, she wrote the song in her bedroom. She recorded the song in her bedroom. And she posted it on YouTube. If your honors have a chance to go to the movies, the Bruce Springsteen movie shows how Bruce Springsteen recorded the Nebraska album in his bedroom, later became a famous hit. She's a singer-songwriter too. Maybe not as famous as the boss, but she's a singer-songwriter. So it was not on school property, not using a school computer, not in a school forum. It's on YouTube. We don't think the school has any even jurisdiction here over this matter.
Counselor, did she cite any specific names of anyone going to the school?
She said many names of people at the school. She named teachers, she named administrators, she named cheerleaders, she named football players, but she has a right to do that. She didn't insult them based on their religion. She didn't insult them based on their race. She didn't claim, she didn't reveal any private facts about them. She didn't defame them. She merely made it clear.
Counselor, were there any effects of that the song had on those people that you mentioned? And if there were, what were they?
The effects that we concede took place and that we think don't count at all in the math were that there were people who saw the video and didn't like it. They were upset by it. Why? Because they were on the opposite side of her side. And there were people that loved it. And then, this is a high school. High school students don't take a vow of silence in the parking lot and just keep their mouths shut the whole time they're in the building. They're generally quiet and polite in class, but in the hallways, in the parking lots, in the cafeteria, everybody's jabbering all the time. That's just high schools. Everywhere we go, people talk. And they talk about the latest news, or they talk about controversies in the school. Of course they do. And some of that's painful, disruptive. People squabble at each other. And they might get emotional about it. The school board thought that's disruption. And so did the district judge, and so did the Court of Appeals, and that's just wrong. You've said over and over and over again that the psychological, emotional angst and anguish that you get when you're exposed to a message you don't like is part of living in a free society. No one was forcing anybody to watch the YouTube video. No, it wasn't in your face. And the fact that there was this hubbub in people talking about it and gossiping about it? Of course there would be. And once the school suspended her, it got more intense. Which,
Did she demand anything in the song, or was it just showing her?
no
disdain?
demand, Your Honor. No, there's nothing in the record to say other than there's a lot of F words in there. We know that's protected under the First Amendment. Cohen versus California, you said you have a right to wear the words F the draft. In the Mahoney cheerleader case, the cheerleader was mad, dropping the F-bomb in all of her messages. You said that's not good enough to suspend her. So it was vulgar. She named people. The theme of not liking the coach prayers is what it's about. And so be it.
Counselor, what options does the school give for students to ask for change? Like, can they go to a student council? Or what kind of things are students doing?
Your Honor, I don't know that there's much in the record here about that. The rule here that she allegedly broke was that this was disruptive of the educational environment, and our view is that it was not. The school board has meetings. Parents can petition the school board for things. Students can write petitions. A student council presumably could have, said, we think the coach shouldn't do this. But it's not her obligation to go through any sort of specific processes to protest what the coach is doing. She made it clear she doesn't think what the coach is doing is right. She has a right but she has a right to write a song about it.
Does she have any other relation to the coach?
No, Your Honor, there's nothing in the record to suggest that.
Counselor, does she have a history of demonstrations like this?
Does she have a history she has a history of writing songs. She has a history of writing edgy songs. She has a history of writing songs about things that matter to her. And that's all she's done here. I mean, she didn't come into the school passing out, versions of her song. This was something she did on her own time in a social media platform. And whether she had a history of being an activist or a history of being a protester is absolutely irrelevant. Many of the people that have been in front of this court and won First Amendment cases were activists, were people that were engaged in trying to get social change. Martin Luther King, you name it, and so that can't be a disqualifier.
Counselor, what I mean, I guess, is like, has she personally contacted these people?
No, Your Honor, there's nothing in the record to suggest that she sent a copy of this song to anybody, which could have been seen as some sort of aggressive move. Nothing to suggest other than this was a passive post and people could access it.
Counselor, did the tradition stop after she posted this video?
Pardon me, Your Honor?
Did the tradition by the football coach stop after she posted this
No,
video?
no. The activity is going on to this day, and she's against it to this day. She thinks it goes beyond what you approved in the Kennedy versus Bremerton case, but that's not before this court. Whether what the coach is doing is right or wrong isn't the point. The point is whether my client can critique it, which is all that she's done here.
Counselor, is she currently suspended from school for this?
Your Honor, she was given a 4-week suspension, and the suspension has been stayed. It has been held in abeyance pending the end of the litigation. So she is in her senior year now. If this court makes a decision on her favor, she'll never be suspended. If it rules in favor of my friends on the school board, then she'll have to take the 4-week suspension.
Counsel, what was she trying to gauge in this video?
Your Honor, I see that my time has expired. Does the court wish for me to answer the question?
What was she trying to gauge?
So I'll take that as a yes, that you'll allow me a little extra time to answer the question. I think the first important point, Your Honor, is it doesn't matter. That is to say, it's not her burden to explain or justify her decision to do it. But I think the simple answer is she was expressing her protest. She was expressing her anger. She was expressing her disagreement with authority. And what she had to gain was venting that expression.
Well, Counselor, you say that she said like the names on social media. Do you think that somebody could go through the video and find those names and then attack like the person?
And Your Honor, again, I'm over my time. If the court wishes me to answer, I take it. the mere posting of the names in and of itself doesn't cause harm in any sense that has ever been recognized by this court. I mean, plainly, the posting of your names can't possibly do that. You're public servants, and the critique of you, the teachers, the coaches, the principals are government employees, authority figures within the school. They got to take criticism too. The fact that the student named them by name doesn't invade any legal interest. If Your Honor is suggesting the naming of a high school student's name somehow is in itself, it's not a threat, just naming, a threat. Students all the time, I would bet 100,000 times a day, use their smartphones, engage in some social media post in which they've named somebody by name that's a friend or somebody they hate or somebody that's in the schoolroom. Just the naming of it doesn't do anything. There would have to be a defamation, an invasion of privacy, something along that order. She didn't give anybody's addresses. She didn't dox anybody in the traditional sense. So it's our view, Your Honor, that the fact that she named names cannot in itself be a grounds for suspending a student or disciplining a student. Thank you, Your Honor. Mr. Smolla, you may proceed. Thank you, Chief Justice. Chief Justice, may it please the court. I'm Rodney Allen Paul Smolla here on behalf of the Union School Board. Your Honors, this court has said again and again, you said it in the Bong Hits for Jesus case. You said it in the Hazelwood newspaper case. You said it in the Fraser case. You've said it over and over again. Federal judges, even Supreme Court justices, are not school officials. You don't know what it's like to be the principal of a high school. You don't know what it's like to be a librarian at a high school, a teacher at a high school, a coach at a high school. High schools in this country, public high schools, have thousands and thousands of students going through their teenage years, and the schools are doing the best they can to create a semblance of order and focus and civility so that they can carry on their mission. And when the school officials reach the judgment that a student has targeted a school and said things about that school that are disruptive to the mission of the school is allowed to engage in discipline.
Counselor, in what ways is this student defaming the school?
Your Honor, that's not the basis of the school's action. So my friend kept emphasizing over and over again, oh, there's no defamation. Oh, there's no defamation. There doesn't need to be. Under the Tinker standard, we accept that it's our burden to show that there was disruption or a threat of disruption. And we have. The record says there's disruption. The trial court found there was disruption. And you should defer to that decision from the people on the scene that saw what was going on. This did, in fact, cause emotional disturbance and anguish to the people named. And maybe it's true, as my friend has suggested, that you Supreme Court justices can take it. Yeah, that's your pay grade. But should the fellow students have to see their names on YouTube and excoriated for praying, which they have a constitutional right to do? The school is entitled to say, we want the school to be a civilized environment, we want it to be a safe environment, and we don't want posts by our students on social media that target the school and disrupt what the school is trying to accomplish.
Counselor, did this video make any student feel unsafe or threatened at school?
The finding of the trial court is that there were students that felt psychological disturbance and upset by being targeted. And there were people.
Is there a quantification of this psychological disturbance?
Pardon me, Your Honor?
Is there a quantification of the psychological disturbance?
There's no record saying how many students had to go to counselors. Did students have to get outside psychiatric help or things like that? But again, remember, that's not the test. The students aren't suing for infliction of emotional distress. The test is whether the school officials could reach the reasonable judgment that there is enough disturbance to these students that their educational environment has been compromised. And that's what the...
She's still protected under the First Amendment. She's a citizen.
Your Honor, of course, what's at issue here is the extent to which that protection creates a license that allows her to do things that are disruptive to the school environment.
Counselor, are you implying that the students against her video are, I don't know, preferred by you to have the constitutional rights over hers? Are you implying that their rights are more important than hers?
The Tinker Standard says, Your Honor, that material disruption or interfering with the rights of others are grounds for discipline. So remember, Tinker was a black armband worn to protest the Vietnam War. That's a far cry from a video naming by name people and saying, I know who you are, I know where you are. That's a different animal. And so it is our position, the students don't have to show they are defamed. The students have to show, I've been named in a very vulgar video, constantly insulting me, using the F word against me, saying I know who you are, I know where you are, and now I got to go to school with everybody talking about this video. That makes it hard for me to focus. That makes it hard to do what I'm supposed to be doing.
Counselor, in the following days after this video was posted, was there any classroom learning time disruption, and were any students not able to fully learn to the best of their ability?
There's nothing in the record that says that actual classroom activities were disruptive. The school's position is that that's not where the disruption was located. It was located in all of the controversy that surrounded the events, and that it should have a right in an instance such as this to say, chill. The school didn't immediately kick her out. The school said, would you please take this down and relieve the pressure cooker here? Because a lot of the people that are in this feel threatened, and a lot of people are disturbed. And we...
How did you know that the students were disturbed if you didn't keep record of students going to counselors or students missing school or students getting outside?
So I don't want to mislead the court by my prior answer. There is in this case a record of the complaints of the students and their parents, and there's a record of the grounds for those complaints. And there's the record which the school was entitled to give credit to, that the students suffered this distress that they recited, that they distressed. And all I meant to say is there's nothing in the record that then goes more deeply into medical visits and so on. But I don't understand counsel for Ms. Bay to be disputing that there was disturbance of the type we've described. What I think I heard my friend Mr. Smolla say was that disturbance doesn't count. And
Does the school board always proceed with the same actions for any type of gossip that has a negative impact on any student on the school campus?
so there's nothing in this record, Your Honor, to suggest that this is some kind of selective prosecution, that the school treats disruptive behavior differently depending on the perspective of the person, depending on whether it's critical of the school or uncritical of the school. So there's nothing to suggest that. If what Your Honor is asking me is, do the penalties vary? Is there discretion in whether they give a student a warning or not? The answer is, of course, yes. Of course, yes. In the course of a school year, there may be a handful of very serious cases in which a student is suspended from the school entirely, severed from the school. And then there's scores of minor cases in which there might be a temporary suspension of some kind or some other sort of penalty. Of course, there is some. And I want to emphasize the school did warn her and just asked her for the civilized gesture of, would you please take this down? And she refused. That did heighten the tensions. And it was against that backdrop that the school said, we've given you the chance, you wouldn't do what we asked you to do, we're going to impose the suspension because we feel an obligation to protect the whole student body, including the people you've named by name.
Counselor, did the student complain about the prayers before the video was posted?
Yes, and so before the video was posted, the actions of the coach generated significant controversy, as you would expect. And there were people, particularly non-Christians, who were against it because they thought it was an establishment of Christianity in the way the coach led the prayers. There were people that backed what the coach did.
So, Counsel, you're saying the prayers did cause a disruption?
There's no question that the coach's prayers were controversial. And there's no question that the school board, on advice of counsel, read the opinion of this court that said the coach has a right to do that, and so the school board let the coach alone. You decided that the coach had a right to do it. The school board said it, and she was upset by what you decided. She was upset by what the school decided, which we concede she had a right to do. And we concede she had a right to write a song about it.
Counselor, if a student does have complaints about the school, what would you deem as an appropriate way for them to express them?
The student is entitled to use vulgarity in criticizing the actions of the school. You decided that in the cheerleader case, in the Mahoney case. And the school the student is entitled to name at least school officials by name. Say, I think this is a bad policy. I think what the coach is doing is wrong. We don't contest that. But the vulgarity laced with the names, laced with the I know who you are, I know where you are. Why on earth do you have to say, I know where you are? I know where you are carries the implicit threat. I know where you live. I know what car you drive. And I know where you are is the kind of disturbance that a person could subjectively decide is a threat. And the court here found that she was reckless in relation to that risk, which is what you said is to be the Counterman test.
Counselor, have there been, further than just gossip, has there been any action or immediate threats by other students in the school towards people who are siding with the coach?
So thankfully, Your Honor, there's no showing that any violence ensued, that any physical attacks ensued, that any stalking ensued. And it's our position, Your Honor, it's precisely because the school stepped in to say, well, this is not allowed, and engage in its position, which is we won't tolerate this. And that may itself have damped down the intensity that might have caused trouble down the road.
Counselor, how is it going to disrupt her school day having to come back from 4-week suspension while everyone else continues their school as normal?
It is the price a student pays for suspension.
Counsel?
And so, yes, Your Honor.
Wait, why didn't you do? Why wasn't suspension forced if it was such an important kind of?
Your Honor, as a litigation matter, the trial judge said, I am going to not allow you to enforce the suspension until the litigation has been completed. So that was the trial judge's decision. We did not resist that. We said that's a fair point, Your Honor. We're not insisting. If she had been suspended and served the suspension, then her remedies would have presumably been something like money damages against the school, something of that nature. We, in a civilized way, said, we think we're right, you think you're right. We won't actually take the action until the courts have run their course.
Counselor, so what has the student been doing in the meantime?
Well, the student's been attending high school.
And has there been further contact?
There isn't anything in the record other than people still talk about it. I can guarantee you today, people are at the high school listening to this oral argument, and I'm sure when the oral argument's over, there's going to be students talking about both sides. I hope the school, goes through that. But that's not the same thing as targeting people, naming them by name, and so on.
How long after the video was posted was the student asked to take it down?
Yeah, essentially immediately, Your Honor, within days.
Within days. And do you think that if the student did take it down, people would not talk about it at all?
Your Honor, if she had taken the video down, there may have still been discussion, but the threat quality, the fear quality of the targeted students would have been gone.
Your Honor, the court has already said in previous cases that the threat is determined by physical acts of violence or arms. So the argument that you're saying that the pure words that she used in her song that count as a threat, I would say holds no weight.
Your Honor, your point's well taken. So we have 2 points there. The first point is that the Counterman case itself doesn't appear to turn on physical violence. The singer-songwriter there was being stalked, was being tracked. It looked like this person may have had some kind of obsession or crush with her. It made her fearful, but there wasn't any showing that it was on the verge of ripening into some kind of attack, some kind of sexual attack or physical attack. And we don't think the proper way to understand threat law is that it's only a physical harm that could count. People threaten people with, foreclosing a loan or economic damage. There are all kinds of ways that a wrongdoer may engage in a threat. But I have another level of answer, Your Honor, if you'll indulge me. And I see my time is about to expire, but if the court will give me a minute. It's our position that the rigors of the Counterman test aren't what we need to meet in the school setting. You might kind of think of it as threat light or Counterman light. That is to say, the risk of the emotional disturbance causing emotional disruption to the students. If objectively the school officials could reach that judgment, that should be all it takes in the context of the school environment. And the case I'd point you to, Your Honor, is the Frederick and Morse decision, Bong Hits for Jesus. So when the student held out the banner, Bong Hits for Jesus, and the principal came running to the banner, most of the students did what a well-adjusted person would do. They scattered and ran for it. But the one student, disciplined, was sat there holding the banner. And when confronted with, what are you saying, Bong Hits for Jesus, that student did what teenagers have done since the beginning of time, gave the classic answer. I didn't mean nothing. I wasn't meaning nothing. I didn't mean to do anything. All right? But the school interpreted it as, who do you think we are? We know what a bong hit is. You're advocating illegal drug use. Students sit down. I said Jesus, And what you said is, you got to defer to how the school officials would reasonably assess the situation. And that's what we're asking the court to do here. Thank you, Your Honors. All right, game's not over. Now you're in the room where it happens. So if you know the great Broadway play Hamilton, right? There's a song, The Room Where It Happens. If you go to the U.S. Supreme Court, you can tour the Supreme Court building, and you can see the conference room where the justices meet. I got once I was able to teach a class there. I brought a class there, and we had class in the room where it happens. We just had watched an oral argument, and we got to talk about it. One then came and talked to the students about it. So it was very cool. But you're now in the room. No one else is allowed in the room when you're in the room. So here's what we'll do. I'm going to be quiet because I'm not technically allowed in. I'm the lawyers, all right? The floor is open for people to suggest how you think the case should turn out. So we'll have some discussion, and then we'll vote on it. So any of you that want to bravely say to your colleagues who you think should win and why, It's your opportunity.
I think the girl should win because she has the freedom of speech to say what she said. It was outside of the school's jurisdiction, and they're punishing her for that. That's going to set back her 4 weeks of schoolwork.
And she also didn't actually threaten anyone. She just said people's names and used the F word.
And the threat of like, I know where you are, it wasn't specified of like, oh, I know where you live, or I know what car you drive. It was really, I know where you are, which could just be like, I know you're at the school because I go to school with you.
So it could be that's the lyric that fit, man.
There's also not any like physical action taken afterwards of the song. So with that other like court case, there wasn't any physical violence that was attached to it.
The disturbance is only being stretched on by the school pushing this into the courts.
I think they both have a point. Because, I think they do. Because I feel like obviously the girl is protected under the right to free speech. They can't, like, shut her down. But they also have the right to do discipline. It's a school. They can enforce their rules how they would like. The rule for what you can and cannot say in a school is different than what you can and can't say just in general.
But she never
Yeah,
said
she-
this in the school.
Yeah, it was
just
posted
posted.
outside of the school on a public global forum that she made by herself in her own space. That was brought into the school through conversation.
The basis of the entire school board's argument is that it caused disruptions. I mean, I think we can all look back on when we were in high school, if one person got suspended or there was one gossip there, it's going to have the same effect, I think, on a lot of people, whether they're being talked about, or if someone posts a song and they get suspended. Everyone's going to continue talking, and I think it will cause the same disruption. Whether this case was specifically different is up for us to interpret, but I think we need to represent that. It's the disruption of the case of everything else.
And who's to say this disruption was greater than the coach's disruption on the correct or not this year?
There's also not any like evidence of disruption in the classroom. It's just outside the classroom, just gossiping around. They're not learning. Yeah, with no specific quantification, there's no way to say that the prayer had less of an impact than her song did. Because there's no quantification of those different complaints there.
Y'all, people in the school can punish us.
I think a minor point to that though is that the impact of the prayer versus her video, while some people didn't like that the prayer was going on, I think that's something that's a little easier to kind of personally, whether you make the choice or not to ignore, that's kind of up to you. And if you choose to be upset by that, then that's on you. And if you can just kind of go, okay, this is their thing and I can ignore that, then that's a personal choice. But I think the video being posted that directly calls people out by name is more of a direct message than I'm going to the football field and I'm going to pray before a game because that is my choice of me as a person.
We weren't given all of the facts of the complaints about the coach, though, and about the prayers. So I feel like we don't have enough information to make too
We
large
don't have
of a
enough
claim on
information
that.
about the gossip either. We don't know what was said. We don't know what was really done with the school year. So I understand where you're coming from. I think there's a way to see that on both sides.
I'd like to also say that this isn't the first time the issue of the coaches or the disabilities has been brought up. It's just the most, I think, direct and most publicized. So it's not like it's one teenage girl who kind of like got out of hand and started posting all their stuff. It seems to be something brought up to the school board that the school board believes is not something that needs to take action against. So I think it seems like maybe the school board is kind of being a hypocrite itself.
Because there's also a history of complaints up against the coach about prayers and people asking him to stop doing that. And he has continued to the prayers. And so she has the right to continue to keep her post up, but he has the right to continue to pray before games.
Yeah, especially since one is in her own bedroom with her own speech and then one is on school grounds, which is something he could do privately beforehand too.
But it's still harassing people in the school. Like, it feels like it's their law.
On the basic constitutionality, it's not whether what she did was right or wrong, it's whether what the school board did to suspend center is actually suppressing your First Amendment right to post the video and spread the information on its own.
And I think no. I think that what they're doing is just disciplining her, and that she has the right to free speech, but obviously not in the same capacity
They're
since it was
punishing her
in
for
a
her free
school
speech, though, even though it
setting.
was out of their jurisdiction.
But it was within their jurisdiction because it's the students who were being harassed. The school has, like,
Didn't they have no claims of harassment, just that there was talk
well,
about it throughout
the
the
video
school?
is harassing.
But
No
I think
claims.
what Jim is saying is that there was the threat of harassment. That is also considered.
And also, the school can punish you for whatever they want.
So I think we have a busy docket. So we're gonna vote. I think we've heard both sides. So how many of you, if you were justices, would vote in favor of the school board to affirm the decision? The school board, okay? And how many of you would vote for Tina Bay, the student? So I would say, doing the math, it would be about a 6-3 vote if we were to reduce this to 9. You're still under the Harry Potter spell. This is going to be painful. I want you to pretend for a minute that you're your parents. Oh my God! All right. If you're your parents, put yourself in their brains. Let's do the same vote. How many of you would vote in favor of the school board?
Is it our kid?
No. You're just parents. You're parents who are Supreme Court justices. Yeah. How many of you would vote in favor of the student? I think the different generation, 5-4, maybe in favor of the school board. I did this exercise in front of my law students a couple weeks ago. They voted about the same as you in favor of the student. How many of you think the actual current U.S. Supreme Court would vote in favor of the student in this case? You don't. I think it would. That is to say, I think the actual Supreme Court today would say there is not enough here to justify the suspension. Might be a close vote, 5-4 in that ballpark, but I kind of think this court would back the student. So I need to warn you, if you continue to feel the effects of being a Supreme Court justice for more than 4 hours, you might want to talk to the school nurse, okay? Your time as justices has expired, but your time as citizens has not. You did a tremendous job. I was very, very impressed. Thanks for having me as your guest.
Two things as we wrap up. One, if you have questions, I'd like to stick around for a little bit and open it for Professor Smolla about how oral arguments work, what it's like to argue before the Supreme Court, as he himself has done that. We're going to have some time to be able to do it. I know the bell rang for 7, but teachers were informed that we would use half of that period. So unless you have something you know you absolutely have to get to, we can stay for that question and answer session. But I just want to do 2 other things before we do that. One, another round of applause for Professor Smolla for and another very big round of applause for yourselves. Dr. Smolla, I apologize, but I gave them the wrong preparatory documents on Friday. So they briefed themselves for the TikTok case, and so everything they did today
Amazing.
in the moment.
No kidding.
Give yourselves a round of
Yeah, that was
applause
great.
for Ron Taylor.
You can ask me about TikTok too, but all right.
So with that said,
Happy to take your questions.
yeah, what questions do you guys have about the Supreme Court, its operation, oral arguments, or
Yep.
being a lawyer?
When you're like, if you have a prepped oral argument and you get interrupted by the judges, does it like disrupt your train
No.
of thought?
So
or your
so the question is, if you have a prepared argument and you get interrupted, does it disrupt you? And the answer is, prepared arguments don't even make any sense most of the time. So I'm going to argue 2 cases in the next 2 weeks, one in Delaware and one in Manhattan. And I have about 90 seconds of prep, and then I'm expecting to get interrupted. And so the way most lawyers prepare is not, I have a canned speech for 30 minutes, because that's just never going to happen. The way you prepare is, You have your quick in and out, to kind of get started, and then you have people bombard you in the practices with the hardest questions they could come up with, and you think through how you're going to answer it. Even then, very often you're going to ask questions you hadn't anticipated, or something emotional will happen that you hadn't anticipated, and you just gotta fall back on your preparation. So that's at least in the kinds of arguments I do, that's typically how it works.
What court are you arguing those at? What are you arguing for?
Yeah, so in a case that's being tried in Delaware, Matthew Perry, the actor from Friends, he overdosed on ketamine, which is an anesthetic, and the Wall Street Journal had a headline that suggested that a company that will, a telehealth company that supplies ketamine, I represent the company. The argument is that the headline suggests that Matthew Perry overdosed on ketamine that they supplied him, and they had nothing to do with him. So it's a defamation case, and that's the intriguing issue. So that'll be in about 7 or 8 days from now, and then this week, I'm arguing a case in which a lawyer working in a law firm went through the online files of another lawyer that through a glitch he was able to get into that lawyer's computer, was his boss's stuff, and get all kinds of private information, medical records, tax returns, all kinds of private information. And this led to a blow up, and the law firm and the lawyer that was invaded sued the guy that did the breaking in for invasion of privacy in New York, and New York claims it does not recognize invasion of privacy. So I am going to be trying to argue that you're wrong. You should recognize invasion of privacy in New York, and here's why. And this is at the trial level, and this will probably go on for 2 or 3 more years. Eventually, the highest court in New York could make the decision one way or the other. So that's kind of the world I'm in. That's the kind of stuff I do. Yeah.
I forgot if you mentioned this earlier, but what is the Supreme Court case that you argued?
Okay, the case I argued is called Virginia versus Black. Very famous case in which I represented bad guys. I represented the Ku Klux Klan and for burning a cross in a racist ritual on a private farm. Virginia had a law that made it a crime to burn the cross because that had been a traditional ritual of the Klan. And I was a lawyer for the ACLU arguing that even though it was evil speech and hate speech and reprehensible, the Klan had a right to engage in its ritual and burn the cross, and the First Amendment protected them. And that's how the Supreme Court came out. So it is in like the Jimmy Kimmel controversy, the Charlie Kirk controversy, practically every other day in the news, when people argue about hate speech itself is protected under the First Amendment. The case I argued was one of the cases that created that. What's not protected is a threat. So I said in the case, if the Klan burned the cross in somebody's yard to threaten them, that's not protected by the First Amendment. If there were other facts that made it clear that this was a directed threat against somebody, of course there's no protection. I also argued you could have a neutral law, like a neutral law that just regulated violence. You don't have to mention the burning cross. You don't have to pick a particular symbol out. And when you pick the symbol out, that infects it with viewpoint discrimination. So you could argue that each way. Last year when I did this, we did the oral argument on the TikTok case. That's why you got the wrong stuff. I didn't do it this time because the Supreme Court decided the TikTok case, but I saw a hand in the back. No, so the question is about the tone. So the way it used to work in the Supreme Court was it was a free-for-all. And I told you I got asked 70 questions. I could barely get an answer out, and I get another. For the most part, the questions are civilized, but they're pointed. And you can sometimes hear in the justice's voice where they're coming from. And I was heavily negatively questioned by Justice Scalia, and he was pretty belligerent, in his questioning of me. Justice Thomas, who historically had never talked in oral argument, which is not so unusual. A lot of justices do that, changed the whole atmosphere that day by talking for the first time in 10 years on the court. He has this, like, Luke, I am your father, voice, and it stunned the courtroom. And he was talking about what it was like as a black kid growing up in the South, having to see the rituals of the Ku Klux Klan and how that was a reign of terror. So he was very emotional and personal, and that really changed the atmosphere. We still prevailed in the case, but it really changed the atmosphere. When COVID came, the court switched to remote arguments. And when the court switched to remote arguments, they made a decision, instead of the free-for-all, they would go justice by justice by justice, and each justice would get a few minutes to question, then they'd pass it on to the next person. Then when we came back after COVID, Chief Justice Roberts thought, actually that's a better way to do the oral arguments. It's a little more orderly, it's a little more civilized. So I think some of you listened to the tariff arguments last week, which were terrific. If you did, you may have, maybe it was a different class, but it's more orderly now. But it's generally respectful, even if the justice is opposed to what you're saying. Yep.
You briefly mentioned Justice Thomas. Can they expand on a personal story, or is it very plain?
They could do whatever they want. And so justices will sometimes tell a personal story. Justices will sometimes stake out where they're coming from. It can be a little misleading. It can be a little deceptive. You can't always tell from the arguments how they're going to vote, because sometimes they're just testing people and trying to see where they think they are. Now, in lower courts around the country, so if I argue a case in the Supreme Court of Texas, or I argue a case in the Federal Court of Appeals, they still follow that old free-for-all format, which I kind of like. It's exciting. I kind of like that. And you got to be ready for that. If you are, yeah.
So the case that we just mocked up, that's still being talked about, decided right now.
The case we just did?
Yeah.
All right. The case we just did is a figment of my imagination, and you're not going to like this. I was at Hanover High School about 3 years ago. And I was going to give a regular talk, and I decided to do a case, make up a case. So while I was waiting, I made up the case. I just made it up in my brain. And the reason the person's name is Tina Bay is Tina Fey, flipped and was in my mind. That's how I got Tina Bay, all right? And then, 3 weeks later, I was scheduled to come here. And I thought, that was a pretty good fictional case I made up. So I actually wrote it out a few years ago. But I think I should rewrite it, because I think it's a little too slanted to the student. So if you have any ideas, send them to Mr. Selesky so he can let me know, because here's what I'm thinking. The lyric needs to be a little more dangerous, because I know where you are is a little too namsy-pamsy. But if I make it too much, and I got a gun or something, then so I'm trying to think of how I would modify the lyric to make it a little scarier, so I'd get a 50-50 vote when I do it. And so if you have great ideas on how to rewrite the lyric, let me know.
When we do the First Amendment, they're going to hear about the Alanis case.
Yeah.
And so maybe we'll.
Alanis is a video case involving threat law. Yeah. Yes.
You could also change, mention the content of the video itself.
Well, one of you could do it. We could actually do, my son's a jazz musician. Maybe he should record the song, and we should actually show it. That would be cool. Yeah. I know you got to get going to your classes. I'll take 1 or 2 more questions, and then I'll be happy to be good.
When you not get stressed so hard, your job.
So the question is, how do you not get stressed? Here's the answer. When I was a young lawyer, growing up in Chicago, I was terrified of authority. And so to me, I grew up in a Polish Catholic neighborhood in Chicago. To me, the Pope, my dad, and the head coach of the Chicago Bears were like the most authoritarian, you know. And I was afraid ever to talk back to parents. I was afraid. I went to law school, and I was terrified to do moot courts and stuff. So I got sent to argue a case in downtown Chicago as a young lawyer. It was, you know, it wasn't a great big case, and it was in September, beautiful time of year in Chicago. I had about a 5-block walk to the courthouse, and I was so scared and nervous that by the time I got to the federal courthouse, I had soaked through my suit. I mean, I'm not talking just my shirt. I mean, it was embarrassing. So I went into the men's room, tried to do the dry thing. I almost had a heart attack in the courtroom. This wonderful old judge could tell I was scared to death. I was probably 24 years old, helped me along, limped through it. And I made myself overcome the fear. I did it over and over again. I started to get cases, and now I crave it. Now, like, I send messages to friends. If you get the flu and you need somebody to come and argue the case for you, let me know. It's just practice, and you'll find this is true. I was basically a shy introvert. I still am very introverted, except when I'm on stage, and like you're on stage in the courtroom, and I just practice gives you a different skill set. You all did great. Thanks so much for having me as your guest. I really appreciate it.